Okay, good morning then everybody and welcome to this second and final general session of this Common Core of European Private Law, the 27th General Meeting. As you know, the session and the entire conference has a clear topic that is law at the center or at the periphery of regulation. My name is Mauro Zamboni, I'm professor in legal theory here at the Faculty of Law, Stockholm University. And my role here, as yesterday my colleague Kelly Chen has explained to you, is to be both chair and commentators. I will most function as a chair simply because I have the feeling my role here is the role of, you know, these bands that usually open up to the big stars in the rock song concert. Well, in the public, you just say, get off the stage, we want to have the stars. We are not very interested in what you want to say, and I totally understand. That's why I will introduce our stars, which are really true academic stars. First one to speak will be Anna Di Robiland. She's professor at Boston University. Then she will be followed by Max Liles, who is also professor at the University of Gothenburg. And finally, we will have online Richard Wright from the Chicago-Kent College of Law. Professor also, of course, and for him, I'm particularly grateful to Professor Wright because I know it must be 3 or 4 o'clock in the morning in Chicago now. So really, if you're online, thank you very much again, Professor, that you could wake up so early just to attend this conference. The organization of this presentation is this session, sorry, of the conference is quite clear. We will have 3 presentations, starting with Anna, then it will be followed by Max, finally with the presentation of Richard. Then we will take like 15 or let's say half hour coffee break. After that, we will have mostly question and A, because as I told you, I would like spare you my comments on this extremely interesting presentation that are to be. And so I will give much more the floor to the speakers and what they have to say. That's why we are all here. Perfect. Thank you very much. Then Anna, the stage is yours. Thank you.
Thank you so much, Mauro. Thank you so much, everyone, for being here physically in the room and remotely. I want to start by thanking the historical organizers of this conference, Ugo Mattei and Mauro Bussani. I also want to thank this year's organizers, Filippo Valguarnera, Kelly Chen, for their wonderful organization and hospitality. And I would also want to thank Hedda Brinklert for the amazing logistical work. Thank you so much. It's a pleasure and a joy to be here. I would also want to thank a number of friends that over the years have inspired the analysis and vision of property law that I will present in a couple of seconds. My 2 intellectual mentors, academic mentors, Ugo Mattei and Duncan Kennedy, and a number of friends largely connected to the Law and Political Economy Network, Tala Syed at Berkeley, Jedediah Purdy at Columbia, now Roni Mann at the Academy in Berlin, and Brishan Rogers at Georgetown. All of their ideas have been deeply inspirational in recent years. So the question I will be addressing today is European property law at the center or at the periphery of resource governance, of the systems for governing valuable, fragile, and scarce resources? And my answer is it could very much be at the center, but it needs to be fundamentally reconceived. Fundamentally reconceived analytically to show its inherent social and relational nature, property as a set of social relations that are inherently competitive social relations around valuable resources, but also a normative and programmatic reconceptualization, a normative and programmatic transformation focused and centered on the values of democratic socialism. So shaping property relations that are that serve the values of distributive equity, of sustainability, and democratic participation. Many of us in this room have spent years studying what I call the property tradition that we know in Europe as Romanist bourgeois property law. An ideological and conceptual tradition that was invented. It's an invention, it is a tradition invented around a notion of Roman property's absolute dominion that never existed in Rome, never existed anywhere, because even though it is a powerful rhetorical tool, it's a practical impossibility. A tradition that was invented, a tradition that is historically contingent, was invented between the end of the 18th century and the 20th century by jurists in Europe and in the informal post-colonial periphery of Europe, particularly in Latin America, jurists who were deeply steeped in the various local permutations of classical liberalism and the 19th century liberal ideology. A tradition that is very rich. It consists of a long inventory of diverse tools. It includes, of course, dominium, but also the concept of abuse of rights, the concept of social obligation of property owners. It includes a vast menu of property forms, or better, forms of holding and governing resources that runs from, yes, robust individual property to more graduated and nuanced forms like emphyteusis, the long-term lease, or the commons, fiduciary property, and even for some usufructus. Most importantly, it's a tradition that has been deeply influential. The wind may have changed, as Ugo Mattei wrote several decades ago now, but these ideas, the Romanist bourgeois property tradition, is still immensely influential to this day, and even outside of Europe. So, for example, the notion, a robust notion of ownership, definitely inspired by Roman dominium, is the centerpiece of a modular architecture of property designed by Henry Smith, who is to this day the most cited American property law scholar. At the center of this architecture of property, there's a robust notion of ownership focused on the right to exclude. Of course, the justifications are different, are not the classical 19th century liberal justifications, but rather the concerns about efficiency typical of late capitalist markets. So lowering information costs and promoting the efficient transfer and use of resources by the highest value user. The jus abutendi, the infamous jus abutendi. Another important aspect of the Roman bourgeois property tradition that has recently seen a revival in U.S. property scholarship. Leor Straville hits a couple of years ago in the Yale Law Journal, responding to Joseph Sachs, who was arguing that American property law has been too permissive towards the destructive acts of owners. Strahilewicz argued that actually the rational decision to destroy certain types of property, works of art, antiquity, correspondence actually serves fundamental expressive interests that should prevail over the competing concern about waste. Another big candidate for a revival has been the notion of abuse of rights. Notion of abuse of rights that was so controversial in 19th century and 20th century Europe, with some seeing it as this continental drug that produced highly disagreeable effects, and others seeing it as the path to a more just and equitable society, and that today is being revamped by Larissa Katz, a Canadian property scholar who argued a couple of years ago that abuse of rights should be a foundational concept of modern property systems, a foundational concept that interrogates the motives of the owner and that demands the owner to provide an agenda for the use of the resource, an agenda that needs to be reasonable. And finally, last but not least, the social function of property or the social obligation of property, another central element of the Romanist bourgeois property tradition that in the last 10 years has been revived, has been at the center of a very vocal and intense debate in the United States, mostly by the Progressive Property School. Gregory Alexander published 10 years ago an article about the social obligation of property, arguing that in American property law, a social obligation imposed on owners has always been at work, even if unrecognized. And the social obligation demands is meant to promote the acquisition of the fundamental capabilities for human flourishing and a minimum of redistribution through a duty to share. So all these tools have been immensely influential, but can European property law still be central in a future transformative agenda? And what is our role as European property scholars? Is our role simply to produce a lucid analysis of how Romanist bourgeois property operated to support the needs and the demands of liberal capitalism and now of late capitalist markets? Or is there a role beyond that, a more central role, a role in proposing a sort of broader, visionary, transformative property framework? And I'm obviously inclined to argue in favor of the second. However, with a condition: to produce a transformative property framework, we need two fundamental moves, which Tala said in a recent article described at denaturalizing liberal property and de-reifying liberal property. So a normative reorientation and an analytical and programmatical reorientation as well. So the normative, let me start with the normative one, going beyond liberalism. C.B. Macpherson, who's probably a great British scholar, who's probably the most lucid analyst of possessive individualism, the possessive individualism that permeated 19th century absolute dominion, went well beyond a critique and an analysis of possessive individualism. He proposed a form of democratic socialism where meaningful and democratic communities mutually empower their members to express their individuality. So a form of democratic socialism that still has a big focus on the individual in a form of expressive individualism rather than possessive individualism. another European, a continental European, German, Wolfgang Streeck, recently published on the New Left Review, is similar inspiring version. The future of Europe is not a reinvention of US liberalism, is not a reinvention, revamping European social democracy, but rather, in his words, stewardship towards a moral community that is necessarily imperfect and in need of improvement, but that makes sort of foregrounds the fact that we depend fundamentally on each other and we owe to each other. Eric Olin Wright, not a European, but one of my favorite theorists, who proposed a transformative framework, what he calls, with I think a wonderful title, Real Utopias, Transformation Through Real Utopias. Again, a new form of social and economic order where, of course, the individual, the market, and the state are still present and are still important elements. But social power, the power of citizens and social actors, is dramatically deepened and expanded. So again, the values of distributive equity, democratic participation and voice, and long-term sustainability. So if these are the ideas, the general vision that should guide our work, our analytical and programmatic work in property, how does that analytical and programmatic work look like? Are there tools in the European property traditions that can still be used to serve this vision? And my answer is yes. They're not the ones that have been so popular in recent years. They're not the social obligation of property, which still presupposes liberal property, corrects liberal property by imposing a minimal set of limits on the right to exclude for anti-discrimination purposes, and a very minimal redistributive role for property. It's not abuse of rights, which again presupposes a robust notion of property rights, of private property rights, and corrects it ex post by focusing, even on its most recent reiteration, on the very mild concept of reasonableness, a reasonable agenda for the resource. So it's neither of those. It's a set of other tools that we're all familiar with and that emphasize the inherently social relational nature of property and the plasticity of property, our ability to reshape property relations to serve these values of participation, sustainability, and distributive equity. So the first of these forms is, surprise, surprise, the infamous dominium divisum. Dominium divisum is a beautiful description of the intimately relational nature of property, where property entitlements are allocated between two owners, a direct and a useful owner, and where in an inherently competitive relationship where entitlements for one owner mean disentitlements for the other, and these entitlements are shaped around the specific resource, which is land. The other tool that I would like to recenter is the spectrum of different forms of holding resources that we find in the European tradition, from dominium all the way down to more fine-grained and lighter forms like emphiteusis or usufructus. The third tool is probably the most important one, and one that has been completely neglected until very recently outside of Europe, and that's the Roman law of things, the focus on resources, the idea that property consists of social relations that are competitive and resource specific. And that means not only as some contemporary economists and legal scholars, from Eleanor Ostrom to Leanne Fennell, argue, focusing on the physical characteristics of the resources, shaping property to reflect the physical characteristics of the resource, shaping property to reflect the attributes of resources, whether they're rival or excludable, resource systems and resource units, but also in more fundamentally the values and interests implicated by different resources. And I like to think about the work of the French Romanist Jan Thomas on the religious things in Roman law, which really emphasized values and interests. And all the wonderful European 20th century literature on the res mancipi, for example, which were another resource-based category that focused on really fundamental social and economical resources that had unique values. The fourth and final tool that this vision should, transformative vision should recenter is the commons. Again, the Roman idea of res communis. And not in a sort of purely structural and liberal sense of mixing individual and collective property entitlements to scale property regimes efficiently to different types of resources, but really focusing on access and voice. And many of us in this room have done work along those lines. So I think, for example, of Saki Bailey's, who was in a Swedish, who is an U.S. scholar who's based in Sweden for many years and part of this group, and has done wonderful work around as an activist now around the community land trust as a way of decommodifying housing and taking housing permanently out of the market. I think of Ugo Mattei's work on the Teatro Valle project in Rome, access, participation, voice, and access in the management of a really important historical cultural institution like the Valle Theatre in Rome. Most recently, as you probably know, Chile is going through a deeply transformative moment, rewriting its constitution, and the commons are an important part of that process of reimagining the Chilean society when it comes to the governance of such a critical natural resource as lithium. Chile is one of the largest producers of lithium in the world, and the commons promise to be are being considered as a way to redirect the extractive interests of foreign firms and foreign investors towards a more inclusive and shared form of social and economic development. So I will conclude here. Thank you, everyone, and I look forward to working with many of you in future years on some of these topics. Thank you.
Bellissimo, veramente bellissimo, grazie. Thank you very much, Anna, for this beautiful and encompassing, really, presentation, really, and extremely inspiring for a discussion that we will hope have during the Q&A. Now is the turn of Max Liles, who is professor at the University of Gothenburg. Veramente bello.
Okay, well, I'd like to thank the organizing committee for a fantastically organized conference and also for being invited to speak. And I will cut to the chase and get started immediately. Okay, facts and customs beyond the regulatory powers of law. Let's see, I was supposed to use this one. Yes. Okay, introduction. In the invitation to this conference, the topic of the conference was framed as what is the relationship between what we commonly consider legal, quote unquote, and other types of norms? What are the advantages or disadvantages of regulatory strategies that rely on a mix of official law with other normative systems? How does the fundamental structure of a particular legal tradition influence the acceptance and success of such strategies? An additional question that could be posed is, what is the common core of self-regulation through commercial usage or commercial business practices or customs? Namely, sources of law that function outside the traditional beaten track of black letter law and legislation. The examples of areas of law where such practices are relevant are many. In EU law, for instance, we find commercial customs that make up part of the international private law, mainly with regards to prorogation clauses, etc. Commercial customs also make up some part of the competition law. If we look to the TFEU of Articles 101, 102. In Nordic and Scandinavian Swedish law, we find it in international private law, of course, but also in the law of contracts, sales, property, etc. And I will restrict myself in this presentation to a Swedish case regarding banking law, or actually the law of obligation, which illustrates some of the points that I wish to discuss. So let's see if we can. Nope. Oh, sorry. So let's see. The main aim of this, or the aim of this presentation or text, is to discuss and explore how the different legal systems, for instance, the Nordic legal family of law, understands and treats privately established and exercised practices in a legal context on one hand, and initially I was also supposed to cut over to the European Union law and see how that or that legal order understood the same issues. But for matters of time, I will focus on the Swedish and Nordic tradition. So let's see here. What I wish to do is identify and define the function of business practices, as I choose to call it from now on, in order to avoid, at least try to avoid the normative, inherently normative understanding of, for instance, commercial customs, handelsbruk, handelsbrauch, etc. And when analyzing the traditional sources of law. What I wish to study and compare is the conditions under which such commercial or business practices, that is facts, attain the status of law. Soft or hard law, it really doesn't matter. And thus gain the mandate to act regulatory or self-regulatory in a specific area of life. That is, become a custom of law or a legal custom. Business practices will be studied as a fact of law or discussed as a fact of law, and rather than being studied as a source of law. I'm not really that interested in discussing the specific rules of themselves, rather the process of establishing certain facts as law. So let's see. And furthermore, I also intend to explore under which conditions various business practices attain status of law, custom, commercial usage, lex mercatoria, etc. And when such practices gain the mandate to act as self-regulatory facts in the legal order. So let's continue. So what is the scope and delimitation of this presentation? Well, the delimitation is the specific object of inquiry is the concept of or actually the fact of business practices, and various synonyms wherever we might find them, be it EU law or Nordic, Scandinavian contracts, acts, etc., etc. And what I want to exclude is customary law proper. So I'd like to focus on the dealings of purely commercial actors. And it's the regulatory power of commercial practices that I wish to study, and that's a delimitation in part motivated by the relative frequency of case law that deals with this type of issues, and we can find commercial usages and practices in several different forms or another, and so. But in this paper, I will only focus on Swedish case law, or a Swedish case which illustrates the conference topic, namely the relationship between legal and other types of norms. The specific rules expressed by or in business practices will therefore not be studied per se. What I will study in particular is the functions of commercial or business practices in law, and therefore also the conditions under which such practices become law. In this respect, I'd say that the study is perhaps methodological, wishing to see how the courts act and why. And from a theoretical point of view, the study is of course positivistic, as I see that these facts in some manner must be studied as social practices. The normative effects of business practices will be treated as consequences of law and the legal order, which however have normative consequences insofar as legally recognized commercial practices are treated normatively or treated as normatively relevant patterns of law. So let's continue. Oh, that's where I am. So a little bit of theory, etc. So I will not delve into any evaluation of the rules as such, or the material content of the business practices themselves. So issues such as the inherent material fairness, justice, etc. of the rules themselves will therefore not be discussed. Neither will the rules be studied materially. So what I have is a hypothesis. There are several issues that could be compared. I mean, who are the actors, the commercial agents, be they natural or legal persons? What kind of actions and activities do they undertake that affects the content of the legal order, be it practice, etc. Actual business patterns could also be studied, and the regulatory or normative effects of such business patterns as well as how courts, that is, and theory, practice and legal theory, assess or judge or evaluate the regulatory normative effects of such practices. Any differences between the Swedish, Nordic systems and EU, etc. My focus is What is the function of the normative concepts such as handelsbruk or commercial practices, customs, etc., in a specific legal system? My hypothesis is that the function of business practices is to allow other contractual mechanisms than those expressly than those spelled out in domestic black letter law to provide an additional default position for the contracting parties. Business practices are, in thus, you say that they are a vector that infuse business experience into the legal system. If we use an analogy to the ongoing, perhaps, pandemic, I don't know, or if it's finished. Well, anyway, what function does this vector serve in domestic systems? Well, my hypothesis is that it serves the function of allowing established business practices or patterns, social patterns, to attain a self-regulatory, that is, normative function, albeit that this is only self-regulatory indirectly, insofar as that pattern has to fulfill certain criterions. It has to be stable, widespread, exercised, accepted, acquiesced to, etc., in order to become legally relevant. So, by means of case law, I will illustrate this hypothesis, or at least open up for discussion. Now, let's see. Yep. Okay. I go back to a case from that's 12 years old now, NGA 2010, page 467. It's a Supreme Court case from Sweden. I see that Jori Munuka is here and he's commented on it, but I'll take my take on it is to discuss or at least illustrate how the Supreme Court deals with an inherently tricky issue. In this case, the background is that a financing house, we can call it, they had the practice, which is quite common, to buy up old archives from banks, including their stocks of promissory notes, skuldebrev. And then they would sift through them and see if they could find any golden nuggets. That is, any debt that they perhaps could claim. However, in this case, they did sue a claimant, sue a debtor, or at least a person who they thought that they could sue successfully, because that person did not have any evidence or proof of that he had actually paid the debt. And since he was not the possessor of the promissory note, and neither did the promissory note contain any annotations that the debt had been mortgaged, he could be sued again. And according to the Swedish Promissory Notes Act of 1936, I believe it is, Section 15, you have to pay again. That's about it. You have to pay the bearer. Unless you can put the bearer in some kind of bad faith, namely by having annotations on the promissory act note. Okay, so what happens in this? What is the major problem here? Well, of course, if this company had been successful, they lost eventually. Then that would actually mean that most of us that have any kinds of mortgages on our houses, loans, etc., will stand the risk of having to pay up again, unless we can prove that we've settled the debt in full by providing, for instance, a receipt of some kind. The debtor in this case had a stroke of bad luck, since once the debt was paid, their house caught fire, and their receipts were destroyed in the ensuing fire. Anyway, the Supreme Court reinterpreted the meaning of Article 15 of the Promissory Notes Act, hereinafter the P&A, with reference to changes in actual business practices as evidenced by the opinions submitted by the Swedish Bankers Association as well as the Association of Swedish Finance Houses. That is, what we have here is, oh, sorry. How do you return? Okay. And these business practices, or new business, or relatively new business practices, at least with regard to the Promissory Notes Act of 1936, were business-wide. There were changes in payment routines, archiving routines, as well as an argument that acting according to the express stipulations of the Promissory Notes Act would mean an increase in costs, because then, in that case, more or less every time a mortgage was paid, the debtor could actually demand that the promissory note was produced, have a little signature on it. As we can see in this case, this is an American promissory note, but we can see here that they have a little, they have a mortgage stamp there. So every time they paid off, they'd stamp it, etc. And that would, of course, complicate the daily business routines of any modern bank, as well as technological advances in the area of information technology. A lot of these annotations, etc., could be recorded digitally. But however, banks, etc., they don't have to keep their record for more than 10 years, and then they can delete them also from the computer systems. And this motivated and the development and establishment of a new regulatory framework. That's at least my take on this case here, with respect to the meaning and effects of possession of a promissory note, a negotiable promissory note, that is, of course, and whether or not it should be returned or destroyed upon payment, or annotated or stamped, etc., etc. So, in the relevant area of business, thus, the business practices of the members of the Swedish Bank Association and the Swedish finance houses meant that specific rights and obligations of creditors and debtors effectively fell into desuetude. That is, they were abrogated in some aspect, or at least this section of the Swedish Promissory Notes Act was reinterpreted in a manner that is quite hard to press into the actual wording of the case, at least according to me. Anyway, so a new regulatory framework was thus established by the introduction of new business practices from the banks and financing houses. So, in the relevant area of business, the business practices of the members of the Swedish Banking Association and financing houses meant that, as I said, that specific rights and obligations effectively fell into desuetude. And thus, that, however, was countered to some effect by the Supreme Court, who established a new meaning of good faith in these matters, since the idea is that there was the standing principle before this case was that the possessor or bearer of the promissory note had more or less unlimited good faith, could more or less practically find the promissory note on the street. Wow, this is interesting. Take it to whoever should pay and demand payment. And So in these areas of debt law, and ultimately doing so with reference to business practices that abrogated statutory provisions to some aspect there. So once established, these business practices, I'd say, exerted decisive influence on the uses, if we return to Roman law. That is how the actions of the relevant actors in this area of business, and also their opinion of law, opinion juris, you could say, of the banking sector in general, and did so in a manner that perhaps banks and financing houses perceived as rational, expedient, and therefore justified, while customers, mainly individual debtors, who perceived the actual payment of the debt as the fact that finally settled the obligation, and despite the formal wording of the Promissory Notes Act, was an act of law, juridical act, rättshandling, that extinguished the debt, but they accepted and endured the new business practices as a matter of fact. If one wanted to have one's promissory note, you would probably be met with, well, okay, let's see. Will take us a while. We have to return to our archives, which we have actually outsourced to a cheaper to an area with a lot cheaper rents than Stockholm. Effectively, the computer says no. So just accept the fact. So the Supreme Court's acceptance of the new order of business practices as decisive or liminal for a central principle in the doctrine of promissory notes, namely the promissory notes' negotiability, is however not without cost for the financing and banking houses, who on the other hand have the risks in the market of the trade with promissory notes shifted to their disadvantage by restricting their objection of good faith of new possessors of promissory notes. If you're active in this area of business, you have to know that this is these are the facts of this specific business. So it turns the good faith of new possessors, or at least certain types of commercial possessors, promissory notes, about. It's almost a 180-degree turn. The Supreme Court accepts the changes of business practices initiated by the actions of the bank and financing sector, but dislikes the effects that these unilaterally initiated actions entail for the debtors. And therefore, the Supreme Court also changes the allocation of risk by assuming that commercial actors, banks and financing houses, actually are aware of the fact that the debts behind promissory notes probably have been paid in full, or amortized on, or amortized, and that good faith does not preclude the knowledge of such facts and the effects of the current business current business practices. Here we see an example, I'd say, of self-regulatory or self-regulation, praeter legem, or perhaps even contra legem, with reference to changed circumstances, new business practices, new routines, etc., in the banking sector. So, why is this example illustrative? Mainly because the Promissory Notes Act does not actually refer to any customary customs, etc., which, on the other hand, for instance, Contracts Acts and Sales Acts do. And thereby enabling self-regulation as a matter of fact. This is a corollary or a logical consequence almost to, or an effect caused by the altered business practices of the finance and banking sector. Neither does the Supreme Court in this case refer to customs. If you read it, you can't find it. They just say that, well, they seem to have new routines. But it still argues in a customary manner, or custom law manner. So they take in opinions from the banking associations, etc. What is the state of the art in this area? And they accept them as evidence that there has been a change in business practices. So the Supreme Court looks to the existence of the practices, their degree of generality, spread, stability, but also takes the mandate to censure or limit the effects of the newly established practices. So, summing up. Yep. Let's see. So, characteristic for the regulatory powers delegated to private actors, if I'm allowed to extrapolate a bit, is the fact that the legal system or legal order, in theory, leaves only a limited area to open to non-state regulatory models. At least this is the case in modern legal systems under the rule of law, or what Ugo Mattei would call legal systems governed by the pattern of the rule of professional law, where the state seldom criticizes the courts and the judiciary's choice with respect to the source of law. They might criticize the outcome, but when it comes to the technicalities, they say, well, okay, well, tend to accept them, and if they don't, they just change legislation or institute new legislation. So, and the interpretation and application of the specific rules of law may, however, be open for debate, but more criticism is generally directed against the citizens and their failure to abide the law. The professionals of the legal order are thus free, I'd say, to let's see, okay. The professionals of the that's free to decide when the transition from black letter law to unwritten law, or from unwritten law to some kind of established law, black letter law, established precedent, is to begin, and under which specific circumstances. However, this narrow path of self-regulation seems to be placed in social areas where the actors have rather long-standing traditions of self-regulation, such as the commercial areas, where the actors themselves seem to take upon themselves to shape or frame the area in which they act legally. So, areas that are also often characterized by their technical nature, or legally technical nature. That is, areas where politicians, such as Christina Ramberg commented on yesterday, seldom go private law. I mean, it's established, and then just don't rock the boat. So, these are areas that are channeled on the one hand through institutions and organizations. They're public, they might be semi-public or totally private, trade unions, commercial organizations, etc., that expressly decide either or both policy and rules, standard agreements, ethical codes, and soft law, etc., for the self-regulation of specific areas of social life. On the other hand, this happens through constant adaptations, I'd say, of limited area, it's technical, it's adaptive as well. Constant adaptations of the actions and content of the rules through the development of what I will call as concerted practices. Perhaps a quip, but nevertheless, it's not concerted practices really in the meaning of competition law, but it happens to be that the actors in the market tend to go in the same direction. And the development of also cartel-like semi-secret business practices of a certain degree and quality, of generality, stability, etc. Let's see here. And legal conviction, acceptance, etc., among the commercial parties, traders, that is, in the relevant branch of social life. It's a question of where we have that it should reflect a social good in some manner, or superior social end. And that eventually will evolve into semi-consciously defined relational regulatory instruments. So, to sum up, commercial usage, business practices, and other synonyms constitute sets of facts that have regulatory effects insofar as private entities or enterprises and their practices under condition that the courts don't find these practices detrimental to whatever social good that is supposed to be the basic value in this area of business or social life. Say, for instance, competition in EU law. And let's see here. Sorry. Are allowed to regulate trade in accordance with how the actors on the market regularly and generally act. So that is the doctrine of sources kind of kicks in here. Well, anyway, commercial actors will invariably establish commercial practices and that are the results of autonomously, or at least on a micro level, in the form of contracts, or organically on a macro level in the form of socially established patterns, customs, that evolve business dealings and practices. Such established practices may, if widely accepted, give rise to rules of law that are binding for the actors or agents on or in the concerned or relevant market. However expedient such rules may be for the stability, foreseeability, and efficiency of the markets, courts and other relevant officials may consider such practices and rules as being detrimental to the function of the market itself, and therefore prohibit or otherwise intervene against such practices by, for instance, limiting its scope. In conclusion, are facts and customs beyond the regulatory powers of law? Of course not. But facts and customs work or function in a regulatory manner outside or parallel to the beaten track of legislation and lawmaking, insofar as such facts provide the needs as they provide the needs of general social practices with a legal form, which prima facie leaves a minute, nearly non-existent field of regulation. That is, when we focus only on legal theory and the doctrine of sources, we find that customs, etc., tends to be might not actually make it into the doctrine of sources. But if we shift focus on lawmaking from legislation to social facts, such as business practices and their potential to regulate beyond law, which perhaps is an oxymoron or a contradiction, the opposite is also true, as lies invariably seems to circumvent law and therefore force law to adapt to the needs of life. Thank you.
Thank you, Max. Very, very interesting presentation that we will discuss further during the Q&A. And then as a third speaker, we have Professor Wright from Chicago-Kent College of Law. Thank you, Professor. Thank you, especially knowing that it is quite early in Chicago now for these uncomfortable hours for you. So the floor is yours. Thank you.
Thank you, and I hope you can all hear me. I wish also to thank the organizers and the administrative staff as well, who've been very helpful for me. I had hoped to attend in person. I always much prefer to attend these sort of things in person because not only in the formal sessions, but outside the formal sessions, there's a lot of good discussion and meeting friends and talking about ideas. But given the pandemic, I decided a couple of weeks ago that it was too much risk and burden of going through 4 or 5 different airports with all their different restrictions and testing requirements to show up for this presentation. So I hope you'll bear with me in presenting from Chicago remotely. I want to touch on various aspects of the proposed topic, the stated topic of the role of private law with respect to regulation and public law and the interactions between them. I begin by saying that I think that we should limit the use of the term regulation to actual legislative or administratively promulgated and enforced rules and standards. But that doesn't mean that only regulations have regulatory effect. I think all of law and much non-law, social norms and so forth, have regulatory effect. They are all norms, legal and non-legal, are intended to affect, influence, sometimes enforce certain types of behavior for specific purposes. I think that the issue really is, what is the best way to try and regulate behavior, and especially through law, and what are the relative roles of private law and public law in doing so? Now, this, of course, raises the distinction between private law and public law, which some say doesn't really exist. I think it does. I think that private law is really aimed primarily at looking at the interest of particular individuals. It focuses on claims by particular individuals against other individuals in terms of contract, property, whatever sort of a tort, whatever sort of area we're in. So private law is intended to really regulate interactions among individuals in terms of whatever the proper notion of relationship of individuals is supposed to be or thought to be. Public law, it's not as if it kind of isn't focused on the same sort of thing, but it's focused on the society as a whole. So it focuses on trying to focus not so much on the, in general, in terms of the specific individuals involved in an interaction, but in terms of the overall interest of society as a whole, of each and every member of society, you're taking them as society as a whole. Now, if we think of it that way, then the issue comes down to how do the various parts of law, private law and public law, interact, and especially through regulation. How should they interact? To what extent should private law defer to regulations? To what extent should it supplement regulations? How do they interact with one another? So I want to begin with that, and I want to begin just by briefly actually referring to a very important paper recently published by Donald Nolan in a festschrift in honor of Peter Kane, published by Bloomsbury just in January. The title of it is Taking Law Seriously, Essays in Honor of Peter Kane. And Donald Nolan has a very useful paper in that collection entitled, Tort and Regulation. It's chapter 9. There's also a useful paper by Jenny Steele, chapter 10, on regulating relationships. The one that's of more interest to my topic today is Nolan's. And he discusses, fairly thoroughly the issue of the relationship between regulation as typically narrowly defined and private law, implemented through court decisions and so forth. Especially, he focuses on tort law, which is also my main area of interest. and focuses particularly on the issue of whether or not regulation should be deemed to have conclusive effect, either in terms of compliance with the regulation or non-compliance. And this raises issue, of course, related to supposed regulatory compliance defenses, preemption issues, statutory preemption, breach of statute as a means of inferring negligent behavior, for example, in tort law, statutory authorization, and so forth. So, for example, a doctrine which is, what should statutes really have in terms of particular tort law decisions, let's say, in particular cases? Should they have conclusive effect, either in terms of compliance or non-compliance with them? Nolan argues, and I agree, that in general, they should not have conclusive effect. But for a number of reasons, and he talks about the fact that that they set broad sort of standards that do not take into account specific instances, specific situations, and even though they're often defined more precisely than general standards in tort law, for example, reasonable care or nuisance law, that they often are not framed any more specifically. They just kind of, for example, talk about best practices, in terms of product liability standards, for example, and that there really should be, there should be a situation, unless there is very clear legislative intent to preempt the field in the legislation, there should instead be the fact that these regulations are taken into account as part of the mix in deciding whether or not particular conduct, for example, is real as a matter of negligence law or nuisance law, and that they should not have conclusive effect, in part because the regulations often are instituted after conduct has already occurred, and really you need, tort law as a backup or a backstop to regulatory sort of things. There's often situations in which, there's regulatory, capture in cases which you want to, overcome that regulatory capture by special interest. There is, let me find out here. There is also the fact that the regulations sometimes really focus on a little bit different issues than tort law does. Tort law, for example, may be interested in the compensation of individuals, even where the behavior is deemed to be proper as a matter of general public behavior. There may be reasons to have strict liability, for example, in nuisance law or in tort law, or in private necessity cases, for example, where we're saying you really, as a matter of private necessity, should go ahead and trespass on this property, but nevertheless, you have inflicted a harm upon somebody else's property, which it's not clear as a matter of justice that they alone should have to bear. So I agree with, and I recommend to people reading Nolan's paper in terms of the fact that regulation should in generally not have conclusive effect. Now, when you take them into account in individual tort decisions, I think there is a difference in how you should take them into account in whether you're talking about compliance or non-compliance. The argument that if you've complied with the statutory regulation or with a regulation, statutory administrative, that therefore you should not be found liable, you should not be found negligent, is again, even in terms of the same sort of thing in terms of compliance with voluntary sort of standards. the regulation ordinarily sets a minimum sort of standard, right? And it's saying that this is the sort of thing you should do at least that much. But as Judge Learned Hand said in the famous T.J. Hooper case in the U.S., it doesn't mean that just because this is kind of the way things ordinarily are done, it's the way it should be, the way it should have been done in this particular case. There may be reasons in this case where that there should be recognition that more is required, particularly since these standards are often set as minimum standards, right? They're often set as rules that that, for example, have been developed in consultation with industry. The industry thinks, we should do at least this much, but it doesn't mean in terms of considering the effects on individuals in individual tort cases that there shouldn't be compensation. Now, I want to shift a bit to this distinction between private and public law, and the fact that, as was discussed, I think, by Professor Romberg yesterday in the first general session, that whereas regulations and public law are generally based on statutes, that private law is, in common law jurisdictions anyway, often based on cases, on precedents, on judicial decisions. And there was some interesting discussion of that yesterday in terms of, what the implications of that are. There was some discussion that, and I think it's often sort of thought that, in civil law jurisdictions like in Europe and most of Europe, that that the source of law is always legislation, it's always statutes, it's always civil codes, and that that cases are merely, brought up as illustrations of the application of those, but not as themselves as having any particular authority, and that basically one has to kind of always go to the statute, and the statute resolves the issue. And that in the development of statutes, both in common law and civil law jurisdictions, that there is typically quite careful attention paid to all the various interests involved in a supposedly much broader and thorough way than can be done in an individual tort case. Now, in part, that's true, but I think I question whether or not that really is the true story of most legislation. I think, at least looking at legislation in the U.S. and looking at code provisions in Europe and so on, these are often fashioned really based on not very much research into what's going on, often biased toward a particular sort of interest, and often are quite broadly written, and in fact require judicial interpretation to have any sort of meaning at all. For example, the general clauses in most civil law codes, simply provide that you're liable for harm caused by your fault. There's no definition in the statutes, in the codes, of what constitutes fault, what constitutes causation, and only a little bit of what counts as a legal injury. It's up to the courts to resolve and interpret those, and it's the court decisions that interpret those that, whether or not you want to recognize it as official precedent or not, really makes up the great body of the law of any jurisdiction, I think, in a civil law country as well as a common law country. The notion that judges shouldn't be doing this, they're creating law, is that it's unavoidable. That it really has to be done. It can't be avoided, and that the judges, when they do so, I think it was argued in part yesterday that when judges are deciding individual tort cases, for example, they're looking only at the particular facts, the particular case. They don't take into account broader interests. I think, again, that that's wrong. I think that if you look at the decisions of tort cases in the US and in Europe and so forth, that generally you will find, insofar as the court explains its reasons, that it does take account of not only the result in this case, but how this ruling in this case would stand up in considering its application to other similar cases. And so I think that the courts necessarily have to and do take into account, or should take into account, when deciding a particular case and stating a particular result, that they are forming a rule. They are forming a generally applicable rule. Even if they only announce it as applied to a particular case, they're applying that rule in this case, and should take into account the overall place of that rule and effects of that rule in the overall legal system. I think, therefore, that it's in terms of transparency, that courts should actually explain the rationale for their decisions. And I think courts, in civil law countries, sometimes some courts don't do that very much, especially the French courts, for example, who are known for simply announcing a result and not giving much in the way of reasons, although I think they're doing a bit more of that. But they are through their decisions, they are creating and building up the body of law that applies in a particular jurisdiction. The concern about judges being activists, they cannot avoid being activists. Of course, they should try and make sure that their decisions are consistent with prior decisions, or correcting, bad rules and explaining why they're bad rules. They shouldn't, kind of be trying to completely overturn what's in, for example, a statute or a code. They shouldn't be able to do that. Instead, the legislature should be able to kind of, change the judge-made rule if need be. And that's true in the US as well as in Europe. But frankly, one of the most activist courts is the French court, right? Which is, again, taken what was meant to be a general rule of fault liability and turned it into almost a general rule of strict liability through its interpretation, quite activist, inventive interpretation of some of the general provisions in the French code. So I think it is important for judges to be transparent, to explain the reasons for the decisions. And I think that, therefore, also it's important when judges are being appointed to know what their views are in terms of the basic purposes of law. I know there's some disagreement with the practice in the US of grilling judges being appointed to US courts and so forth. But obviously, their particular ideological, whatever beliefs, their positions in terms of what the law is or should be doing is important and crucial. And I think it's important that that be evaluated before they're appointed. Now, if we think about the interaction between private law and public law, and between the statutes and the cases, the issue really kind of comes down to why do we need both private law and public law? Do they serve different purposes or the same purposes? I think it's sometimes thought that public law, and some of the statements were made yesterday, public law really kind of more often serves efficiency goals, whereas private law sometimes is thought to also to do so, efficiency goals, and tort law, for example, in the US, but otherwise thought to serve different goals. I think the underlying basis of all of law is or should be justice, not efficiency. It's not as if, efficiency isn't important in one sense, in the sense, for example, of non-waste, of doing things as efficiently as possible. But the notion of efficiency in the way it's ordinarily discussed in legal literature and academic literature of utilitarian efficiency, I think is an improper goal for law. There is, going back to Aristotle, the notion that the common good should not be thought of in utilitarian efficiency terms, in terms of maximizing total gains, welfare, utility, whatever. The common good really should be the promotion of the equal freedom of each individual in society. And there are two basic problems, in terms of trying to promote people's individual freedom. One is if they have sufficient access to goods, what you might call sort of a positive freedom issue, which is an issue of distributive justice. And the other is sufficient protection of what goods they do have in their person and property and so forth in interactions with others, which has typically been called corrective justice, but I think is more accurately phrased interactive justice, just the justice of interactions, as Aristotle called it. And these are two distinct types of justice. It's often thought that somehow why I don't like the term corrective justice, that corrective justice is a corollary or an adjunct of distributive justice. It merely corrects unjust distributions. I think that's wrong. Interactive corrective justice is a distinct form of justice. Even Bill Gates is entitled to have his goods protected against thieves, right? So you have these two different notions. One is, we need to kind of have distributive justice, which is implemented primarily through public law, although it can come into effect in private law as well. I'll mention some examples, but primarily through public law, and is something which, courts are really not, capable of doing. They don't, especially in terms of material resources, they aren't capable, unlike a legislature or administrative agency, of looking at all the resources in society, looking at all the various claims of merit or need and so forth of various members of society, and reallocating or distributing those material goods among members based on the proper criterion of distributive justice. The courts are able to, however, I think, distribute some important resources like certain basic rights, like freedom of speech, equal protection of the law, right to travel, freedom of religion. Those are things that can be allocated, to individuals without impairing the amount held by others. They're kind of distinct sort of holdings. But on the other hand, if we look at interactive justice, that is kind of the justice of interactions between individuals. And that's where I think, again, courts come into play as being much better suited than legislation or deference to regulations in saying, in this particular interaction, in these sorts of interactions in general, what should the proper rules be in terms of how people treat one another? Now, of course, legislatures can be involved in that. In fact, civil codes, again, do say, we have this general standard, you should be liable for harm caused through your fault. But again, they do not say much about what constitutes fault. And that is something that really kind of often has to be looked at in terms of what's reasonable conduct in these particular circumstances. The same thing in private nuisance law. Private nuisance law is, focused primarily on, is this impact upon the neighbors one that the neighbors should be thought to be required or to accept, in terms of the kind of live and let live sort of principle that these sort of effects they're common in the area, that are unavoidable in terms of us all going about our lives, are ones we all have to accept in this community going forward with life in the middle of Manhattan versus some, wilderness preserve. Different sort of things are bearable and thought to be acceptable and in different communities. And only by looking at those particular communities and what's acceptable to them, can you decide whether or not this is indeed an unreasonable interference, a significant interference as measured by the standards of the appropriate community. I think the same thing goes in terms of reasonable conduct in tort law. It really is based on, common perceptions of what is reasonable conduct. And here I think we come back to the distinction between, law as implementing justice as opposed to law as implementing utilitarian efficiency. Law as implementing justice is aimed at trying to, again, provide, as a matter of distributive justice, the goods we all need in going about our lives, and as a matter of corrective interactive justice, and as a matter of sufficient protection of our goods in the interaction of others. So how should we behave when we do things that are going to affect others, whether it's governed by negligence law or nuisance law? And of course, nuisance law is an overlap between property and tort law, often taught by one or the other. How should we deem the regulations? And it really is pretty much private law that defines those standards of conduct. They aren't spelled out, and they really couldn't be spelled out in the detail needed in regulations or in legislation and so forth. They kind of indeed come down to the particular sort of case in terms of what's going on. And I think if you look at what the standards of reasonable conduct are, and it just so happens that there is a ongoing project of the Common Core group on standards of reasonable conduct, looking at various types of situations to try and spell out in a way that hadn't really been done very much in different types of situations what is deemed to be reasonable conduct. And I must say that, a little advanced briefing, that the general consensus in all the different jurisdictions is that reasonable conduct is based on looking at what's reasonable in terms of its impact upon the people being affected. So even in product liability law, when we use risk utility analysis in product liability law, it's not a utilitarian efficiency risk utility analysis. This is even stated in the comments to the Restatement Third of Torts on product liability in the U.S. It's not a notion of, it's okay to do this as long as you gain more than the other party loses, or if the overall gains added up outweigh the overall losses added up. It's okay to do this only if it has a significant impact upon others, your neighbor or others you interact with in terms of tort law. It's okay to do it only if that impact is one that is thought to be reasonable in terms of its impact upon them, right? One that they would be willing to accept. For example, they're willing to accept certain risk involved in products, given the benefits of those products. They're willing to kind of accept certain risk to avoid increased prices in the product, right? That they'd rather kind of not pay the higher price for safety. But they are not willing to kind of bear the risk because doing so would make greater profits for the manufacturer. So I think in terms of both, if you're looking at kind of the basic normative undergrounding of both private law and public law, it should be based on this idea of what we're trying to do always is to implement justice. Justice, law is, this kind of goes back again to Aristotle saying this. It's said by Madison in the Federalist Papers in the U.S. It's said by Kant, for example, the common good, just the law is an attempt to implement the common good. And we shouldn't try to use law, unlike Aristotle, we shouldn't try to use law to enforce morals, to enforce virtuous behavior. But what we do need to have law for is when individuals an impact upon others' external lives, an impact externally upon others, to regulate that relationship in a way that respects the equal freedom of each individual in society and promotes their ability to flourish equally with others in society. And I think I'll wrap up there.
Thank you very much, Professor Wright, for this very deep analysis. Then I suggest now we have a coffee break until 11:50, that is 10 to 11, and then we'll have some questions, and then after my questions we can open the floor to the Q&A. Thank you very much. Then we will be back at 10 to 12. Thank you.